Chair, the meeting is now live.
Diolch, thank you, Carol. Iawn, bore da pawb a croeso cynnes a bore braf a hyfryd. In opening the meeting, I'd like to extend a warm welcome to everyone here. This meeting of the Planning, Taxi Licensing and Rights of Way Committee. Apologies, we're a few minutes late starting for those members of the public or press who are joining us. Just a couple of technical issues, but I think we're good to go. We have 2 items on our agenda this morning. So we'll start off item number 1, please, Carol. Apologies and roll call.
Thank you, Chair. So Councillor Gareth D. Jones.
Yma.
Councillor Adrian Jones.
Present.
Councillor Tom Colbert. Councillor Angela Davis. Councillor Angela.
Yeah, I'm unmuted.
We can hear you now.
We can hear you now. Councillor Deb Edwards.
Present.
Councillor Claire Hall has sent apologies. Councillor Peter James.
Present.
Councillor Ed Jones.
Present.
Councillor Gareth E. Jones, we're trying to get in, so I'll continue to do that. Councillor Karina Kenyon-Wade.
Present.
Councillor Carl Lewis.
Present.
Councillor Jeff Morgan.
Present.
Councillor Gareth Pugh.
Present.
Councillor Edwin Roderick has sent apologies. Councillor Elwyn Vaughan.
Yma.
Councillor Jonathan Wilkinson.
Present.
Councillor Hugh Williams.
Yma.
That's everybody, Chair. And then we've got 2 officers that will be presenting.
Good, we've got Claire and Shan. Yeah, lovely, thank you very much. Item number 2, minutes of the previous meeting. To authorise the chair to sign the minutes of the previous meeting of the committee, which was held on the 3rd of April 2025 as a correct record. These are on pages 3 through to 8 on your agenda pack. So I'm looking for comments, and if everyone's happy, a proposal in a second that we accept them for accuracy, please. Councillor Vaughan, is that a proposal? Yes, thank you. And Councillor Jonathan, I'll take it as seconder. Any other hands I'm missing? Any observations? No. In that case, I'll sign them as a true correct record. Thank you. Rights of way. We have 2 other items on our agenda this morning. Rights of way. First up, we've got declarations of interest, please. Councillor Deb.
I have to declare interest on item 5, the DMMO order, because it's been done by Preston and Norton Town Council, and I am a member of Preston and Norton Town Council.
Thank you, Councillor Deb. I know you've had a chat with Rachel about this, and I understand that when we come to that application, you'll be taken out of the room. So thank you. Any further declarations? No. In that case, members, I'd like to welcome Claire to our meeting this morning, and we have an application to correct the Register of Common Land, and I believe she's going to take us through it. Claire, how do you wish to handle questions? Do you wish us to take us through to your recommendations and questions at the end?
What would you prefer, Chair?
It's whichever you're comfortable with.
So if we go to the point of recommendation, and I'll pause at that point for questions.
Thank you very much. So Claire, the floor is all yours. Diolch.
Lovely. Thank you, Chair. Good morning, members. An application was received on the 26th of July last year from Mr. and Mrs. Lamb for the removal of land as common land. The effect of this application, if granted, would be to remove 0.015 hectares of common land from the Register of Common Land. To succeed, it must satisfy the legal criteria set out under Schedule 2, Paragraph 6 of the Commons Act 2006. The application form and plan is numbered 1 in the appendix to this report. On screen now on the left is an extract from the applicant's plan, with the area put forward for removal edged in red. On the right is a copy of the Commons Register map, This confirms the current position. The map is drawn on a base at a 1 to 10,560 scale. Under the Commons Act 2006, correction, non-registration or mistaken registration regulations in 2017, publicity must be given to this type of application via the council website and a site notice. This was completed on the 24th of October. Notices were served to all interested parties in line with statutory requirements. One representation was received from Mr. Hugh Craddock of the Open Spaces Society. The Open Spaces Society does not have a legal interest in the land subject of the application, so we must determine it by the Commons Registration Authority. As I said previously, there are a number of legal requirements to be met under Schedule 2, Paragraph 6. And the application must be, to be successful, it must meet all of these requirements. The task of proving the case in support of the correction of the register rests with the person making the application, and the burden of proof is the normal civil standard, the balance of probabilities. Firstly, the land must be provisionally registered as common land under Section 4 of the 1965 Act. This occurred on the 19th of June 1968 and is evidenced by entry number 1 on the land section sheet, as shown in the photo. Secondly, whether on the date of provisional registration the land was covered by a building or was within the curtilage of a building. The history report put forward on RULAS found at Appendix 4, as submitted by the applicants, suggests that the probable date of construction of RULAS House was as early as 1884. The footprint of the house shown on the 1901 first edition 1 to 2500 Ordnance Survey map is comparable with that of RULAS House today. You can see it on screen. It includes a small outbuilding at the roadside to the northwest of the house. This is the site of the present garage at RULAS House and is likely to have been previously a coach or cart house. The history report also states the hard standing area immediately in front of the western facade of RULAS House has retained its status as registered common land to the present day. However, it is clear that this narrow strip of land has been used as a forecourt, an access point to the shop, storage rooms, warehouse, and coach house garage at RULAS House since the building was constructed. Indeed, the shop at RULAS House, which can be charted to have been in use for over 55 years, could not have functioned unless this strip of land was used on a daily basis for customers and commercial deliveries. You can see the hard standing shown on the photograph. This further photograph, taken from the applicant's supporting statement, is presumed to date from the 1950s/60s, if using the car and the phone box as reference. Shop windows and an upper goods loading door can be seen under the roof gable and the building to the left of the house. The statement of Mr. Wilkes, and supported by his mother, Mrs. G. Wilkes, proclaims that RULAS House was a shop during the 1960s. They both recall the driveway as always being a hard standing used for parking of visitors to the property, remembering that the cellar, garage access and front door of the property lead directly onto it. Mr. Craddock of the Open Spaces Society in his representation states, "We concede that the forecourt and garage satisfy the test of having been curtilage of RULAS House at the time of provisional registration and having remained so ever since. However, as to the land on the west side of the garage and that on the south side of the garage wall, there is simply no evidence that the land was part of the curtilage of the house at the time of provisional registration, nor indeed that it has ever become so. This land plainly was and remains part of the common. Mr. Craddock goes on to say that he notes from the applicant's own evidence that a telephone kiosk was sited on the land on the south side until relatively recently, and that the land rest side of the garage has always provided public access to the public postbox. The applicants were served with a copy of the representation, but no further evidence to counteract the claim by Open Spaces Society was made. The third criteria is whether the provisional registration became final. Again, the Register of Common Land records that the provisional registration of the land as common land became final on the 1st of October 1970. The final point to satisfy is whether, since the date of provisional registration, the land has at all times been and still is covered by a building or within a curtilage of a building. The history report contains photos taken in 2024 of Ruler's house, garage and curtilage, and states, the strip of land has continued to be used to the present day, with the main door to the dwelling being on that side, as well as access to the garage. However, evidence submitted by the applicant does not demonstrate how two areas of the application land intrinsically form part of parcel of the house. These comprise the land on the west side of the garage and that on the south side of the stone garden wall. These areas are both shown as laid to grass in the photos on screen and open to the adjacent public highway. So in summary, the first and third legal criteria are matters of fact that are evidence from the Register of Common Land itself. The Register records that the land was provisionally registered under Part 4 of the Commons Act and that the registration became final. The representation from the Open Spaces Society conceded that the garage and the forecourt satisfy the test of having been curtilage of Ruler's house at the time of provisional registration on the 19th of June 1968, and having remained so ever since. But for an application to succeed, it must satisfy all the legislative criteria for the removal of a building or the curtilage of a building from the register. Having regard to all the information put forward, it is reasonable to assume on the balance of probabilities that immediately prior to the 19th of June 1968, only part of the application land satisfies the criteria as a mistaken registration under paragraph 6 of Schedule 2 to the Commons Act 2006. So for avoidance of doubt, the land covered by the building currently used as a garage and the forecourt is shown coloured orange on the attached plan. The grassed areas to the west of the garage and south of the stone wall are shown edged in red. So before we move on to the recommendations, I'd like to hand back to the chair for any questions.
Thank you, diolch yn fawr, Claire. Members, over to you. Cynghorydd Vaughan.
Well, it's not a question, so if you want to take a question, I'll come in afterwards.
Members, has anyone got a question for Claire? Any comments? Any concerns? Claire, I think you've completely satisfied all their curiosities.
Sorry.
Oh, Angela, Councillor Angela, please.
Yeah, so I just had a question about who maintains those patches that are currently edged in red. So if they're currently registered as common land, who is currently maintaining them?
That's a good question, Councillor Davis. I'm not entirely sure. They do look as if they're cut. I presume that maybe the applicant does, but I'm not sure. They are next to a public highway, so if they weren't cut, I would expect the council highways team to cut sort of the verge for visibility reasons. But that point hasn't been raised. It is open to the remaining area of common land. I don't think the land is currently grazed by sheep, but it could be. And obviously that would maintain the level of grass if that was to happen.
Okay, thank you.
Thank you, Councillor Angela. Councillor Peter, please.
Thank you, Chair. I was just interested with the larger piece of common land. Was that where the actual post box and telephone kiosk was on? Or was it a bit further in?
So the actual post box, if you can see screen now, you can see it's on the actual building of the garage. Can you see the red area? I've taken
Oh,
that.
right, yeah.
Yeah, it
yeah.
is actually within the building. So yeah, and then the telephone box would have been somewhere near to where the telegraph pole is on the photo, just below the stone wall.
Okay.
But that's been removed now. But yes, that they were both sort of cited on what is registered as current common land currently.
Okay, so they didn't apply to the residents for having that on that piece of land, or there was no paperwork to say that?
I'm not aware of any paperwork. Like I said, the register, the land was registered as common land back in the 1960s.
Yeah.
If there was works on common land and there is an application procedure to go through, I can only assume that the community were happy with the fact that the phone box had been sited on that area of common land.
Okay, it was just a bit of a clarification of them, so thank you.
Muted, Chair.
Councillor Gareth, please. Apologies.
Yeah. Just two things. Sorry, apologies for joining late, but I've had problems with my laptop, so I won't vote on this one. But just for some clarity, phone boxes can be placed on, have been placed on land that is in ownership of individuals. Like we had 2 in our ward, like that, and they go by that historically. So I don't think we need to bother about where the phone box was really personally.
You are mute, Chair.
Thank you, Councillor Gareth. Councillor Rachel, please. Rachel, sorry, I said that twice now. Rachel, please.
Thank you, Chair. Yeah, it's just to confirm that common land can be privately owned. I don't know what the position is in this case, but just to clarify that it can be.
Thank you. Thank you, Rachel. Angela, you wish to come back?
Yeah, thank you, Chair. So yeah, I think it does say in the papers that it's Watkin wins, isn't it? The common land. They own a lot of common land. I think I read that. But anyway, what I wanted to know, so if this parcel by the garage that's currently outlined red were to be approved here to be part of the curtilage of that property, would there have to be some sort of right of way or something included to give access to that post box? Assuming the post box is still working and being collected.
I'm not entirely sure what the answer is, but presumably the owner of the property is already allowing access, so I would assume that they would be happy with that. Just to come back on the ownership, so the area to the west of the garage where the post box is, that piece is still owned by the Winstay estate.
Winstay, yeah.
The applicant has purchased the remaining land that is subject of the application. So they do have title to the area south of that stone wall and obviously the building and the forecourt. And they purchased that from the Winstay estate, the forecourt and the land to the south. So they purchased that now just a few years ago.
Sorry, when you say the land to the south, do you mean that that's highlighted orange on the map as opposed to the bit that's outlined red on the map?
So the area highlighted orange, part of it is the building, and they would have purchased that with their property. The forecourt area in front of the building, which is also orange, they purchased that from the Winstay estate. And they also purchased the southern parcel, which is edged red.
Okay, so in that case, I'm confused why we're even having this conversation. So if the ownership of land is there, so what they want to do is to take the common land element of it. So
correct.
They privately own it, but it is common land for anyone to use. Okay,
that is correct.
Okay, so they don't presumably want anybody to be able to use it, but the top triangle is not in their ownership. That's still in the Winstay estate. Yeah, okay. But you said then presumably they would still allow access for the post office, for the post box, but we can't presume that that would go on forever, can you? Because if they own that land and it's no longer common land, they could, or somebody else in the future could, be minded to fence it off. So my question remains that surely if we approve this, what the applicants require, there would have to be something there to allow the locality to use their post box.
It would also be unlawful to fence off that area. They would have to get consent from the Welsh Government. I just need to make that clear.
Lovely, thank you.
Thank you, Councillor Angela. I don't see any further hands up unless I'm missing any. No. Oh, Councillor Adrian, please. And then I will ask Claire to take us to recommendations.
Oh, yeah, thanks, Chair. Claire, I presume that the applicants are happy with what you're recommending. They own all around the house, but they want the common land just taken off the forecourt. And are they happy with that?
They obviously applied for the larger area to be removed. However, the Open Spaces Society raised concerns with that, and they received the comments from the Open Spaces Society, and they decided not to provide any counteractive evidence. So, yes, it is my understanding that they are content with the recommendations.
That's fine. Thank you very much.
Thank you, Councillor Adrian. Appreciate that. Good. Right. Claire, back to you, please, if you could take us to your recommendations that are appeared on the screen. Thank you.
Okay, thank you, Chair. There is two recommendations, and I understand that the committee will vote on them separately. Recommendation 1 is that application 24001 be granted in respect of the area comprising 0.07 hectares, that's 0.019 acres, and that's shown coloured orange on the plan at Appendix 12. And then recommendation 2, that the application be refused in respect of the area edged red on the plan at Appendix 12.
Good. Thank you, Claire. Right, we've had the officer recommendations and we've heard them. Is anybody wishing to comment on the applications, or are you happy? In that case, I'm looking for a proposer and a seconder on the first application. As Claire rightly said, that we're going to take them separately. Councillor Vaughan, was that a proposal?
Yes, definitely for both of them. Yeah.
Thank you. So we'll take that as a proposal for the first one. Councillor Jeff, please.
I'll second that.
So we've got a proposal and a seconder for the first recommendation. Anybody contrary to that and wishing to say anything else? No. In that case, Carol, are you happy to put it up in the chat box, please?
Yes, Chair, just give me a second.
Perfect. So for clarity,
So I'm putting it in as 4.1. So it's the first recommendation of application 4, sorry.
Thank you. There you go, members. It's in our chat box. So recommendation 1, application to correct common land as officer's recommendation. Has everybody had an opportunity to vote? Anyone having problems? I'll close the vote. Carol, how are we looking?
I've got 12 votes. No, I've got 13 votes. Just hold on. Yep, so I've got 13 votes. 13 members are eligible to vote. So 12 have voted for the officer's recommendation, none against, and 1 abstention.
Lovely, thank you. So that has been passed as per officer recommendation that application 24/001 CA be granted in respect of the area comprising of 0.007 hectares, shown coloured orange on the plan at Appendix 12. Thank you, Claire. So application 2 now, we've heard from Claire in presenting the case. I think Councillor Elwyn has already proposed this. So again, I'm looking for a seconder for this recommendation.
I'll second it, fine.
Thank you, Councillor Jeff. Any further comments? Are you all happy we go to the vote? I take it by your silence you are. So Carol, would you be so kind as to put 4.2 in the chat box? There you go. 4.2 is there for us now. Has everybody had an opportunity to vote, had a chance?
So Chair, I've got 12 at the moment. So is there somebody not able to vote?
Anybody struggling to vote, please?
Yes, me, Chair. Carl.
Cal.
4.
Cal, are you happy to vote verbally?
Yeah, 4.
Well, thank
You're
you.
4. Okay, that's fine. Thank you. So everybody's voted, 13 eligible to vote, 13 voted for, none against, and no abstentions.
Lovely. Thank you, Carol. So 4.2, the application as per officer recommendation is refused in respect of the area edged red on the plan at Appendix 12. Good. Thank you all. I believe that concludes that. And as Councillor Elwyn has put in the chat box, thank you very much, Claire, for a very clear, comprehensive report. Really grateful to you for making it so clear to us. Diolch yn fawr iawn. Right, members, we've got the next item on our agenda, the definitive map modification order in relation to land at Fold Farm, Prestine. And we have Sian here somewhere. I'm looking for it to be able to guide us through this order. Sian, the floor is yours. Thank you very much.
Thank you, Chair. Just one moment and I'll share screen with you, so just bear with me.
Just before we start, Chair, we just need to move Councillor Deb from the meeting. So if I move her backstage, or Councillor Deb, if you want to move and watch online, you can. So I've moved her.
Thank you, Carol.
Backstage.
Thank you. Apologies for the false start. Jan, floor's yours now. Thank you.
Not a problem at all. May I just check, members, is the screen coming through? Are you able to see the presentation?
Yep, I can see everyone. I'm sure I see thumbs up from Councillor Hugh. Yeah,
Right.
good to go.
Lovely, thank you. So this is a decision with regard to a definitive map modification order application, very similar in nature to the application that Claire has just presented to you, but the difference is that this relates to the definitive map and statement of public rights of way. It's part of our legal duty to ensure that the definitive map is kept up to date and correct as a legal record. The land that's affected is at Fold Farm in Prestine, and the number that's been allocated to the application is Prestine DMMO 001. And the impact of the application will be to add a public right-of-way. So the application was submitted by Prestine and Norton Town Council. It was registered as complying with legal requirements on the 1st of December 2016. So we accept these applications only at the point when they do comply with strict legal requirements. The effect of the application, as I've mentioned, is to add a public footpath along land that is known locally as Fold Farm Lane in Prestine. It does connect with a recorded footpath, PR 1807. The application itself must be accompanied by an amount of evidence, and it was accompanied by both documentary and user witness evidence. So this is a digital interpretation of the plan supplied by the applicant, not the actual plan. You can see that footpath PR 1807 is shown on the right-hand side of the screen as the dotted line and labelled. The application route is A, B, C, D on the left-hand side of the screen, so running from Broad Street and connecting with footpath PR 1807. And just to show you some site photos taken in 2020, just before the COVID outbreak, which seems it's quite a time ago now. The first photo on the left-hand side of the screen, which is in your report pack, is taken from Broad Street, looking towards point D. The second photo is taken looking in the opposite direction. So you can see there quite a well-defined route. And in the photo on the left, you will just about be able to see a sign on the right-hand side next to the blue house, a little bit further back. And this is referred to later in the evidence, so it's relevant to point that out. For the application itself, there are legal requirements again around service of notice. So for this type of application, we don't have to place a notice in the press at the application stage, but the applicant has to serve notice on the owner of the land. It was served on the owner of the land at the time of application, which was Mrs. Susan Meadows. Before Susan Meadows, the late Ted Breeze had owned the land, and that is also relevant to the consideration of this application. Since then, since 2016, the land has changed hands. It's now owned by Andrew Goodwin and Diane Bayliss, who are also aware of the application. There is a very small area of land at the western end, which is unregistered in title. There is a caution against first registration in favour of Welsh Water, who again have been consulted and are aware of the application. So as I mentioned, this is part of our legal duty as a surveying authority to keep the definitive map and statement under continuous review, which means keeping it up to date and correct. It's a legal duty. It does differ from the duties that Claire was describing around under the Commons Act, in that we do have an active investigation duty when we receive an application of this nature. So for an application, a corrective under the Commons Act, we are entitled to consider the evidence as presented to us by the applicant and any objectors. For a modification order, we are required to go away and do some active research, archive research, interviewing user witnesses in order to understand what is the available evidence. Under Section 53(2)(a) of the Wildlife and Countryside Act of 1981, if a specified event has, on the balance of probabilities, occurred, the surveying authority is required to make the requisite modifications to the definitive map and statement by order. We have to make a definitive map modification order. The consideration of these applications is quasi-judicial, which means acting like a court but not being a formal court. The legal standard to be met here is the civil balance of probabilities, i.e., in this case, whether it is considered that it is more likely than not that the available evidence supports the making of an order. So it's not beyond reasonable doubt, it is the balance of probabilities that's the test here. The case must be determined solely on the available user witness and documentary evidence in consideration of the statute and case law. Matters such as desirability or need for the route, impact on land management or cost of maintenance must not be taken into account. So that may seem baffling. It could result in a significant additional maintenance liability. It could result in significant challenges from land management perspective. But those cannot be taken into account in considering this application. In terms of documentary evidence, Where documentary evidence is supplied with an application for a modification order, the Council must consider whether the legal event under Section 53C Part 1 of the Wildlife and Countryside Act has occurred, where it is an addition, which this is, and that is the discovery by the authority of evidence which, when considered with all other relevant evidence available to them, shows that a right-of-way which is not shown in the map and statement subsists or is reasonably alleged to subsist over land in the area to which the map relates. And as you can see there, we're presented, or we discover evidence, and we have to look at all the other relevant evidence available to us, hence that research duty. In terms of the documentary sources that have been considered, there was quite a range of Ordnance Survey maps that we looked at ourselves, but also that were presented by the applicant. Those are described in the decision report. We looked at the tithe map and apportionment as a tax record. The Finance Act 1910 records, which were also a tax, which was never levied, but very, very detailed records were prepared. We looked at minutes of the former Prestine Town Council. We looked at some tourism guidebooks, then as now, Wardlock Red Guides, Prestine Past and Present by W.H. Howes, which was provided to us, an extract with the application, and which we looked up in the local library. We looked at the list of streets and the preceding county roads records. And of course, we looked at the records produced pursuant to the National Parks and Access to the Countryside Act 1949, i.e. the definitive map and statement as first prepared. And we did also look at some land title information. We were not able to identify, we were not presented with any enclosure award, estate records or public utility records that were relevant to this application. If they were, those would also be standard sources for this type of case. In terms of the summary of the evidence, the Ordnance Survey map and tithe map are helpful. They do indicate that the physical corridor along which the application route runs has existed and has changed very little since the early 1800s. They do indicate the presence of gates on it, although it is of note that the location of the gates has moved over time, perhaps not too much of a surprise in view of land management practices. Ordnance Survey maps, though, are good evidence of the physical characteristics of a route over time. That's what Ordnance Survey were commissioned to do. What they were not commissioned to do is to determine whether a path or way was public or not. So the fact that they have depicted a path or way is not evidence in itself that use of the route was by the public. Other evidence sources are needed to assess this. Good evidence of what was there on the ground, not necessarily evidence of the status of the way. So these again are in your report pack. And on the left, you can see here, we have an Ordnance Survey map. You can see the application route quite clearly by this stage as an enclosed route. You can also see some PEC lines, some FPs, which actually run along the same route as what is now PR 1807 that is on the definitive map. On the right, you have an extract from the tithe map, and you can see one of the research challenges there in that I've orientated it so that it is roughly north-south, but the map as presented, in fact, is not north-south. Fortunately for us, some amazing work has been done to digitise those and put them onto the internet as the tithe maps for Wales, done by lots of volunteers, and it does really help us with research. So I've orientated it north-south, but actually, as originally prepared, they were not necessarily orientated in that manner. Again, with the tithe map, you can't see the individual buildings very well, but you can see the location of where Fold Farm Lane is. You can see the start of the lane, again, very early 1800s, hadn't changed much. But in fact, it was not enclosed for the same distance as it is now. Finance Act 1910 records, again, tax that was never levied. They do indicate a deduction for rights of way or user. That is strong evidence that a right of way crossed the hereditament, the plot of land that includes Fold Farm, but it is not clear whether this relates to the public right of way, footpath 80 PR 1807, that was subsequently recorded on the definitive map only, or other routes as well. Other sources would be needed to assess this. So again, this is the Finance Act map, beautifully kept records. You can see hereditament 214, which includes Fold Farm, bounded in that green area of land, produced on an Ordnance Survey map base, so no surprise that it does show the application route. And on the right, you can see the extract that has public rights of way or user. To declare a deduction from tax was an offence then as now. Therefore, if there is a deduction, it is strong evidence that there is a public right of way or user there. But we know that public footpath PR 1807 was later recorded. Does it just relate to that or to something else as well? It is of note that the route was not indicated as a public path on the parish survey documents to be considered for inclusion on the first definitive map, although the adjoining footpath PR 1807 was. This suggests it might not have been regarded as being in public use at that time. So these were people, the parish surveyors, who knew the area very, very well, and they were commissioned to go out to walk the routes and to put them onto the survey map. On the left, we have the parish survey map, and you can see with the blue line, hand drawn as these mostly are, you can see PR 1807 as a blue line. There is no similar depiction running along Fold Farm Lane. On the right, an extract from the first definitive map, and again, footpath PR 1807 clearly depicted in purple, but nothing along Fold Farm Lane. In summary, the documentary evidence assessed to date doesn't really support a reasonable allegation of the existence of a public way prior to publication of the first definitive map and statement for Radnorshire. And I should qualify that is along the claimed route along Fold Farm Lane. Clearly, we do have a recorded right-of-way connecting with the claimed route. Before I move on to user witness evidence, Chair, would it be useful to allow opportunity here for any questions?
Apologies, we're struggling to unmute then. Yes, thank you, Sian. Members, have you any questions arising from what Sian has presented to us by so far? Anybody wishing to query anything? Are you content that she continues? Looks like they're more than happy, Sian, for you to carry on with your presentation. Thank you.
Great, thank you, Chair. So moving on now to user witness evidence. Where user witness evidence is supplied, we need to consider a different legal event. That is the test under section 53(3)(b of the Wildlife and Countryside Act. And that is the expiration of a period of time during which enjoyment of any way by the public raises a presumption that this way has been dedicated as a public path. So this is very often sort of described as gaining a right of way through 20 years usage in common parlance. But it is a much more detailed assessment than that, and there is cat statute and case law around it. So the tests are further described under section 31 of the Highways Act of 1980. So the enjoyment or use of the way by the public must not have been illegal. For example, there are offences related to trespass on a railway line. If someone is committing that offence, they cannot gain rights through doing it. The use of the way must have been brought into question, and we'll describe that more in a moment. The use of the way by the public must have been as of right, so without secrecy, without force, and without permission, as if the public had a right, but without one necessarily having been recorded. It must have been over a period of at least 20 years and without effective interruption. That 20-year period is not any 20-year period. It is calculated retrospectively from the earliest date on which use of the way has been brought into question. And use of the way can be brought into question by an overt act or challenge by the owner or occupier of the land. In the absence of such an act or challenge, the courts have since deemed that the making of an application for a modification order is actually sufficient to bring use of the way into question, so that where there is no identifiable challenge, and this does sometimes happen, the application date is taken to be the date of challenge. In terms of the evidence that we had with this application, evidence was supplied originally for 12 witnesses. These witnesses and the landowner were interviewed, documentary sources were considered, and a consultation report was circulated. For that original evidence, weaknesses were identified. Use of the way was by a relatively small number of witnesses, and actually only 4 of those were identified who had not at any point had permission from Ted Breeze, who owned the land during that period of time, or used the route as visitors of residents on the lane, or been there by right because they lived there and were exercising a right to access their property. So there is an important but subtle distinction: as of right, as if you have a right but you don't necessarily, or by right because statute law says you do, because you live there, because you have an easement. And in terms of those who were visiting the residents, they would have had permission from those residents to do so. Following that first consultation report, statements were supplied by the applicant for another further 63 witnesses. The format that they came in, and they are in your pack, was as identical signed and dated type statements as follows. To whom it may concern, I wish to confirm that during the period from January 1992 and January 2012, I walked along the length of path from the junction of Broad Street, Prestine, adjacent to Fold Farm, in an easterly direction to where it meets footpath PR 1807 from A to D on the map and beyond, freely and without force, secrecy or challenge, for leisure and other purposes, and not just to visit people on the disputed route. So those statements were all identical. And the reference to January 1992 to 2012, you'll see in a moment, that was the originally assessed 20-year period. When receiving new information of this nature, particularly where it is identical in that fashion, it is very important, in fact, to talk to individual witnesses where at all possible. It helps to draw out individual recollections, which can be very important in assessing the application. But particularly given the number, it's perhaps no surprise that not all of the new witnesses were available to be interviewed. All were invited, all were sent privacy statements, as is our standard practice, so that they understand what would happen with the information. Therefore, it was not possible to interrogate all of the new evidence in further detail. Some of those witnesses did annotate their statements with additional information, which is helpful because more individual. But in total, a total of 33 witnesses, original and additional, were interviewed, and the forms completed are appended to the report. And there is also a summary that sets out the key points made by each witness. In terms of what came out of that, levels of use throughout the relevant period were acknowledged to be quite low, with only 1 or 2 people on the route at any one time. The frequency of use for many individuals was also reported to be quite low, perhaps monthly or several times per year. However, a total of 8 witnesses did report more regular use, from several times per month to once a week or more, during the relevant period. And what's important here is that what we're assessing is the body of evidence. It's not about whether one witness used the route for the whole 20-year period. It is about whether there is a body of evidence of usage over that period of time. So we take into account the bigger picture. What does all of that information tell us? There were no changes to the route that the witnesses used over time. The alignment described was consistent, being a well-defined corridor between houses and field boundaries, which you saw in those photos. User witnesses were aware of deterrence to use of the route from 2010 onwards, and signage was evidenced in 2012. Once the additional user witnesses were interviewed, an earlier verbal challenge date in 2008 was identified. The relevant 20-year period is therefore considered to be 1988 to 2008. So what is worth explaining is that when the first consultation report went out, a relevant challenge to the signage was identified in 2012, so it was considered that the 20-year period ran backwards from 2012. However, because one of the new user witnesses did identify themselves a verbal challenge that was earlier, the relevant period has been reassessed and is now 1988 to 2008. This does include the period during which restrictions were in force on access to the countryside due to the 2001 foot and mouth disease outbreak. PIN's Planning Inspectorate, as was, their guidance to inspectors is that this is unlikely to be considered a relevant interruption under Section 31(1) of the 1980 Act. So it is not taken into account here because it was a statutory restriction. The body of evidence does suggest uninterrupted use of the way over the relevant 20-year period. The original witness evidence did raise a question as to whether this use would have brought home to the landowner, Ted Breeze, that a right was being asserted against him, for indeed he owned the land during the whole of that period. The new witness evidence does add significant weight, though. Even without considering witnesses who were not interviewed, or those whose use included visits to residents or properties on the lane, credible evidence has been supplied now for a total of 18 witnesses whose use could be described as without force, without secrecy, and without permission, i.e. in a manner that is as of right. Landowner evidence. The landowner or occupier can negate this deemed dedication by showing sufficient evidence of their intention not to dedicate a public right-of-way within the relevant 20-year period. So this is around the effective interruptions and around the negating of dedication, deemed dedication. Section 31 of the Highways Act 1980 does set out some of the actions that may be taken to negate an intention to dedicate use of a way as a highway. These include, but are not limited to, putting up and maintaining signage that is in such manner as to be visible to persons using the way, a note is inconsistent with the dedication of the way as a highway. That is relevant to this application. Making a legal deposit under section 31(6) of the Highways Act 1980, which is lodged with the County Council, and it's made available for public inspection. We have a register of these inspections that's on our website. Powys County Council does not hold any deposit under section 31(6) of the Highways Act 1980 in relation to the land crossed by the application route. So in terms of establishing whether any other actions had been taken, we did interview the current landowner, Mr. Goodwin, and that was again at the end of January 2020. He has known the land since he purchased it in late summer, early autumn of 2017. His evidence does attest to actions that he has taken to demonstrate his intention not to dedicate a public right-of-way. However, because these was from 2017 onwards, after the relevant period of the assessment for the application, they don't impact during that time of 1988 to 2008. In response to the first consultation report, new information was received from Sue Meadows as the previous owner of Fold Farm and daughter of Ted Breeze, who owned the land during the relevant period. Mrs. Meadows notes that she owned the farm by 2010. So again, just outside the relevant period, however, she was giving memories of her father's actions. She did provide photographs of the sign that was in place at Fold Farm, which she took on 30th September 2010. The sign states Fold Farm, private road, no parking. She doesn't clarify exactly when the sign was first installed, but notes that it was displayed for many years, and this is referred to in user witness evidence. Mrs. Meadows also goes on to state that he, Ted Breeze, was adamant this was a private road with access only for Fold Farm and residents living down the lane, and he lived here for approximately 40 years. However, what she wasn't able to do was provide dates of specific challenges to individuals using the route. Neither did the statements of witnesses confirm that such challenges occurred. Some people noted that they spoke with Ted Breeze, others noted even that he'd given them permission to be there, but none of their statements picked up any particular challenges to using the route from the late Ted Breeze. Before I move on to consultation again, Chair, would it be helpful to allow opportunity for questions there?
Thank you again, Sian. Very, very comprehensive. Members, anybody wishing to query anything? Councillor Hugh, sgwelwch yn dda.
Thank you, Chair. Sian, was there vehicular access to this lane at this time, and is that relevant to what we are discussing as a footpath or what have you? But there's been a few references that residents were able to travel along the lane. Yes. So that, sorry.
Yes, absolutely. Yes, there is, and it is of relevance, Councillor Hugh. Yes, it is a vehicular access. We believe there are private vehicular access easements there. So some of the user witness statements did in fact come from people who did live along that lane and who will have taken that vehicular access through those private rights. Those private rights would not establish public rights as such. The witnesses who gave evidence around this were all saying that the use by the public as opposed to residents was on foot. But in terms of the physical characteristics of the road, it is relevant, obviously, that there is vehicular access. It is a well-defined route. There is a surface on it. It's also relevant to consideration in terms of the signage that's there.
But it's not an adopted road?
No, it's not.
Okay, thank you.
Thank you, Councillor Hugh. Councillor Gareth.
Yeah, sorry, Chair, I just take my hand down because Hugh's just asked the question. I was going to ask about the whether it's adopted road. Yeah.
Okay, thank you. Councillor Peter.
Thank you, Chair. It seems to be coming out that Ted Breeze had like a gentleman's agreement for certain residents to use foot access on this private right of way, but there doesn't seem to be any it's just a gentleman agreement rather than any paper trail with it.
There are a conveyance was provided for a property called Lugside, and our understanding is that the residents have a right of access. Whether those are formally recorded as easements or whether easements have potentially been gained through prescription is not clear. But in the case of residents, the general expectation is that there would either be a recorded easement or sort of an easement gained through prescription in all likelihood, because a lot of those properties have been there for many, many years, Councillor James, Peter. So some of them are a little bit newer, but those properties have been there for many years, and I would expect normally that those access arrangements would be formalised. There is reference in some of the evidence actually to one of the residents along the lane. A resident of Breeze Cottage has noted that actually contributions are made by the residents down there to maintenance of that route. So it seems that there are at least some formal easements around access down there.
Okay, thank you for that.
Thank you, Councillor Peter. I don't see any other hands up. No. Sian, back to you, please.
Great, thank you. So in terms of consultation, this is regarded as good practice and helps us to draw out comments and further evidence. 2 consultation reports were circulated for this case. The first was in February 2024, and because there was submission of significant new evidence, a second was sent out in February 2025, because the new evidence actually did change quite dramatically the assessment of the application. Fairness and natural justice, as it's described, is really important in this type of case. All parties have to have opportunity to see and comment on the evidence, particularly in this case the landowner, because the impact of the application and the new evidence for them could be significant. They need to have a chance to comment on and rebut if they wish to do so. So the consultation report, reports plural, was sent to the owners of the land crossed by the application route. It was sent to the applicant. It was sent to the prescribed organisations as per what is now the Welsh Government's guidance for local authorities on public rights of way from 2016. Those do include the Ramblers Association, British Horse Society, Open Spaces Society and others. It was also sent to statutory undertakers whose plant and apparatus might be affected, and the local member and natural resources wells were also consulted, just as a matter of good practice and ensuring that the local member knew what was happening in the area. This did result in additional evidence as described above from the Town Council initially. Also, 3 residents submitted evidence. They weren't interviewed. In 2 cases, their knowledge of the application route was after the relevant period of 1998, but to 2008. Their information is again in the report pack. One resident made comments about their use of the route from 1966 onwards, noting that they were not challenged when using it until about 5 years ago, so around 2020. So it does add some weight, but we were not able to interview them. The comments made by the Ramblers Association in their detailed response of 24th of April 2024 relate to the original evidence and our assessment of it. These have been addressed through the new evidence submitted, so further comments are not made. In terms of the overall assessment of the evidence officer assessment, both documentary and user witness evidence have been presented to the Council in connection with this application, and both have been considered. The documentary evidence does not point strongly towards the existence of a public way prior to the publication of the first definitive map and statement for Radnorshire. The application is therefore considered to be based primarily on user witness evidence. And in terms of that user witness evidence, there is a body of evidence that the witnesses have used the route over the relevant period 1988 to 2008 collectively, although obviously some individual witnesses have not used it for the whole of that period. It is felt that the additional witness evidence submitted does address the question as to whether the user is enough at any rate to carry to the mind of a reasonable person the fact that a continuous right to enjoyment is being asserted and ought to be resisted if such a right is not recognised and if resistance is intended. And this quote comes from case law. The landowner in the period 1988 to 2008, Ted Breeze, will have recognised the residents accessing their properties, he'll recognise their visitors, and those who acknowledge they received verbal permission from him to use the route. He is therefore unlikely to have had reason to challenge use of the application route by those people on those occasions. Until 2008, neither user witness evidence nor landowner evidence identify specific occasions when challenges to use occurred at all. The remainder of the use during that time is, for the most part, quite infrequent on the part of individual witnesses. However, the body of evidence of these 18 people over the relevant period is significant enough to consider that the landowner would have noted and had opportunity to challenge at least some of the witnesses. So we're not entirely disregarding the fact that a lot more user witness statements were sent to us. The difficulty is that we have not had the opportunity to inquire within to gain the level of detail we would need to assess the weight and the credibility of that evidence. The signage originally put up by Ted Breeze does not seem to have conveyed to users that there was no intention to dedicate a public right-of-way on foot, as its wording related to motor vehicles and parking, so witnesses reported seeing it, but thinking perhaps it just related to not parking on the lane, not driving along it if you were not a resident. As such, in the light of the additional user witness evidence in support of the application, it is considered that use of the way by the public over the period 1988 to 2008 would be sufficient to convey to the landowner that a right was being asserted against him, does not pinpoint actions taken to challenge that right that are likely to be sufficient evidence of the landowner's intention not to dedicate a public right of way before 2008, at which point someone, presumably the landowner, but we don't actually know who, made a verbal challenge to one user witness, Guy Richards, when he went to see his architect. Before moving to the recommendation, Chair, again, would you like opportunity for any questions?
Thank you, Sian. Yes, please, members. Sian's come to the conclusion of her report. Councillor Gareth, please.
Yeah, can Sean just remind us what was the original 20-year period that was being assessed against?
It was 1992 to 2012, just making sure I get my dates right over the millennium. So the original period was 1992 to 2012, and it is for that reason that you see reference to that period in the statements, the additional statements that were provided by the Town Council following the first consultation report.
So what was the reasons for changing the dates? And was that done by the applicant or by the council?
The identification of the challenge date actually is done by the council. It's our assessment of the evidence. So the reason for the change was that in the original application, the Town Council themselves did provide quite clear evidence of a date in 2012 when signage was changed and clearly stated no public right of way. That was quite a clear documentary evidence in terms of that date. However, when additional user witness evidence was supplied and we interviewed the witnesses, one witness, Guy Richards, attested to the fact that in 2008, when he went to see his architect, someone did challenge him using that route. While it was resolved amicably at the time, there was clearly an intention, there was clearly a concern there being raised about use of this route by the public, which means that as a council, we're required to consider that as an earlier challenge date.
Okay. And where did that architect live? Was that on the footpath or?
No, but his architect lived along there, so he walked to see the architect, and it was resolved amicably because that was the case. He was a visitor to a property.
Okay. Just one final question. What's the distance from the last house that it's got rights by easement, whatever, on that lane to the start of the footpath?
Well, in terms of the plan, just bear with me and I will see if I can bring that up because it might be helpful, I think. Just bear with me, members. Excuse me while I flick through. So what you can see here, you've got housing from point A all the way down past point B, all the way down to point C. So I'd have to check on the distance for you, but it's only really from point C to D where you haven't got properties. These are, I think, sheds in field use for livestock. So Hughes Villas is the last property on that lane. So there's actually only a relatively short distance, a matter of, sort of maybe tens of meters maximum between the point C and D where the houses run out.
And there's reference in the documentation to a gate. So where's it?
The gate, at the date when I visited the site, the gate was at point C.
Okay.
It had originally actually been a little bit further back towards point D. So what you can see on that map there, I don't know if my cursor is showing up, is a little triangle just above the path line at point C, which I think was originally some form of turning area. And one of the user witnesses who lives along there attested to the fact that the gate had actually been moved and it had made life more difficult, I think, in terms of being able to turn round.
So there's in effect public right of way through easements and a previous agreement to point C. Whether
for the residents, yes, there would be, yeah.
Okay. Okay. Thank you.
Thank you, Gareth. Any other questions, please? Shannon, can I ask a question, please? I'm not sure how relevant it is. Had that one witness not come forward who altered the dates from 1992 to 2012, do you feel would be still in the same position with in relation to your recommendation? Has that one person altered this application process significantly?
It's a relevant question, yes, because it's something that could come up at a later state where this referred to PEDU. In terms of that, no, I would say say not, because there is still that credible body of evidence. So what the impact of this use of witness is simply to move the relevant period back by a few years. But in fact, we do have evidence that spans a wider period than that. So what I will just do for a moment, if I may, is actually just share the screen, if you just bear with me, one of the appendices that you've got, which actually has a summary of the evidence. Right, just bear with me. Okay, so hopefully now what's coming through is a picture of one of the appendices that you have, Appendix E. I can expand that slightly. Is that visible?
Not yet.
Okay,
I can't see anything yet, no.
No problem. I will try and do that again then. Okay. Is that coming through now?
Something's coming quietly. There we go. Yes.
Okay, so this is Appendix E in your report pack. And what you can actually see here, this is a sort of rough bar chart showing the periods of use of individual witnesses. These are the witnesses who were interviewed, basically. So of all the use of witnesses, you can see I've noted on here the relevant period 1998 to 2008. But if you look at the sort of the bars, they extend considerably beyond that. And you can see the February 2012, the sign. So you can see that actually, again, there continues to be a body of evidence of use over that period between 2008 and 2012. So were the original 20-year period still being considered, there would still be that body of evidence.
Thank you.
And in effect, it shows an increased usage, doesn't it?
There is quite a lot of usage during that time. Yes, of course, as you would expect with these things, the recollections of earlier usage are more sparse.
Good. Thank you for that, Jan. Members, I'm in your hands. Any further questions? If not, I'm looking for a proposer in a second there. No, I'm not. I'm looking, I could ask Shan, my apologies, to go back and take us to a recommendation, please.
Okay, no problem. There we go, and hopefully the recommendation is now coming up. So the officer recommendation in this case is that a definitive map modification order be made in respect of application Prestine DMMO 001 to add a public footpath, as the available evidence indicates that on the balance of probabilities, the legal event under section 53(3)(b) of the Wildlife and Countryside Act 1981 has occurred, namely the expiration of a period of time during which enjoyment of any way by the public raises a presumption that this way has been dedicated as a public path.
Thank you. Thank you very much, Shan, for that. Councillor Gareth, then Councillor Adrian.
Yeah,
amazing.
just for clarity, Chair, that proposed new footpath would extend from Broad Street itself through to where it joins in the existing footpath.
That's correct, Councillor Gareth. So it will be points from A to D on the map shown to you.
Thank you, Councillor Gareth. Councillor Adrian.
Thank you, Chair. Well, I just want to say to Shan, congratulations on an incredible amount of work and investigation. I am satisfied that your recommendation is the right one. So I'd like to propose that we go along with that. Thank you, Chair.
Thank you, Councillor Adrian. Councillor Elwyn.
And I likewise second Councillor Adrian.
Thank you, Councillor Elwyn. Any further comments? Councillor Gareth, please. Gareth Pugh. You're on mute, Councillor Gareth.
Sorry, Chair. Yeah, if the other two members hadn't spoken, then I personally would have gone against it. This chap obviously owns the land. He's been trying for the last 13 years to put signs up to tell him that it's private land. And it seems like he's getting penalised by like his own generosity for letting people cross his land in the past. Yeah, I would go against it. He owns that land. I've got land and I let people go across it, but after listening to what I've heard today, I'll be putting barbed wire around that gate and stopping the public using it, because I wouldn't want them coming back to me in a few years' time saying, we've walked this land for so many years, Gareth, so now we're going to apply for a footpath across your land, which you own, which you've been generous enough to let us cross. So I would go against this, the officer's recommendation on this one. Being a landowner, and I can feel how this chap, well, I can only imagine how he feels. Like you say, for the last 13 years, he's been putting signs up to say private land. I would go against the officer.
Chair, might I just pick up a procedural point? Sorry to interrupt
Please
on
do.
that. Yeah.
Please do.
Whilst we may thoroughly appreciate and have concerns for an individual, unfortunately in this case we are bound by law to consider only the available evidence. What I would say in terms of landowners separately and stepping away from this application, that is just in terms of use of land, we would invite landowners who are allowing the public to use an area of land to come and speak with us about deposits under Section 31(6) of the Highways Act 1980, which is a documentary trail that comes to us. So there are means that landowners can take should they wish to allow that use of land. However, in this particular case, however strongly we may feel about it, unfortunately, we're not able to take it into account.
Thank you, Sian, for clarifying that. Councillor Carl, I see your hand up.
I feel very much the same as Councillor Gareth Pugh on this occasion. This chap has obviously, allowed these people to go across his land, and I respect what Sian says, but on this occasion, I can't support this.
Okay. Thank you for your comments, Councillor Carl. Councillor Gareth,
Yes.
and then I will go to the vote.
Yeah, sorry, Chair. Just one further question. Because the gate at point C is locked, I assume padlocked, I think I read that in the papers, would the council, if we approve this change, would the council look to support by supplying a stile or a small gate to allow public access while keeping the gate locked to vehicle access?
Under these circumstances, if a new public right-of-way is recorded, we will work with landowners cooperatively as we do for every other recorded public right-of-way, and we can look at management provisions. Those management provisions have to be considered separately from the application, hence why there is nothing in the presentation around it.
Yeah, I understand that, but I'm content with what you just said as well, Sian. Thank you.
Thank you, Gareth, and thank you, Sian, for that. I don't see any further comments. I've had a proposal and a seconder to go with officer recommendation. Carol, please, are you able to put the vote up in the chat box? Members, there we go. Item 5 at 11:19.
So, Chair, 13 members eligible to vote and 13 have voted.
Perfect, thank you.
Okay, so 10 have voted for the officer's recommendation and 3 against and no abstentions.
Thank you, Carol. So a definitive map modification order as per officer recommendation in respect of the application before us now has been passed as with the recommendation of the officer. I think the Vice Chair, Sian, mentioned how comprehensive this report was. Can I offer my personal thanks as well for such an impressive report covering so much detail. I'd love to know how many hours have gone into this, but it's commendable of the work that you've carried out. So thank you very much for your professionalism. Thank you, Sian.
Great, thank you.
Members.
Chair, I'm just moving Councillor Deb back into the meeting.
Of course.
Yeah, she's back in now, Chair.
She's back in. Good. Members, I believe that has concluded all of the items on our agenda this morning. Diolch yn fawr I pawb sydd wedi bod yma. Thank you to all for being here this morning. I understand that this is our last meeting of this council year, as it were. and some members possibly won't be returning when the allocation of seats are known to us following the AGM moving forward. Can I personally thank each and every one of you for the way in which we've run as a committee over the last 12 months. I think it's been very effective, and I'm really grateful to each and every one of you for your support. So with that, at 11:20, close the meeting and wish you all a very enjoyable rest of the day. Diolch yn fawr iawn pawb.
Thank you, Chair.
Thank you,
Thank
Chair.
you. Thank you.
Da iawn, Cadeirydd.
Thank you. Bye now.
Thank you, Chair.